Hello and welcome to an essay and lecture on counterplans. I am very honored to be able to present this program on counterplans to those of you attending this very marvelous institute. I have judged many competitors from this college national championship program, and I am honored to be a part of presenting this for you for this summer 2020 institute. What we're going to talk about today is counterplans, one of the great negative weapons in terms of debating skills and abilities. And what we're going to talk in terms of counterplans relate to what are the elements of the counterplan, a little bit of my history with respect to the counterplan starting in 1967 and proceeding up through 1974. And then we're going to talk about, at the very end, how debate saved the world and how it was the counterplan that managed to actually, truthfully, honestly save the planet. And in debate, that's really the only thing that has ever done that. So counterplans are a very valuable weapon in modern debate. They are utilized to effectively allow you and permit you to defend not the system, but to defend a better system than what the affirmative team is offering in the form of their plan. Counterplans are very valuable, and those counterplans that are there have the opportunity for you to have some opportunities to succeed in any particular debate round when you're debating on the negative. But we'll also talk a little bit about debating on the affirmative. The goals and objectives of this hour-long lecture and program are to try and get you to focus and understand that in the counterplan debate, listening is absolutely essential to success. You need to understand where these people are. You need to understand what is going on with the other team's arguments. And you need to have a conscious understanding by the time the 2NR rolls around of what must happen for you to win and what can't happen, because if that happens, you will lose. Finally, we'll talk a little bit about execution of the counterplan, how you can prepare in advance to be an effective counterplan debater, and how you can perform once you get the opportunity to run on the negative. Central to any of this debate and any of this discussion of counterplans is the argument that you have to understand not just what your argument is, you need to understand what the other team's argument is as well. And going through that to understand their arguments, you can't have those going in different directions. It is the intersectionality and the clash between their arguments on the counterplan and your arguments on the counterplan that make you a winning debater in a counterplan debate round. So I told you we'd talk a little bit about my history with the counterplan debate. Probably the greatest question I ever asked in cross-examination in a debate round. Marvin, do you have a card for that? And truthfully, this is for me and my personal understanding of when debate got weird. I started high school debate in 1967. From 1967 through 3 summer institutes, through 4 years of high school debating, through 3 years of coaching at summer institutes after I got done in high school, through 3 full years of college debate, I had never heard a counterplan. I had never been involved in a counterplan debate round. Now we're talking 7 years of debating. We're talking long history of coaching and teaching at institutes for a 3-year period. We're talking tons of lessons and 3 institutes, and I never heard a counterplan. So the issue became, what the heck is a counterplan debate? And how did it come to be that I needed to argue a counterplan? Well, some of you may have heard that necessity is the mother of invention. And believe me, by the time my junior year rolled around and the major national college at Seton Hall University was happening, and the final round of that college tournament was happening, and we at the University of Redlands, me debating as a junior and my partner as a freshman, were meeting on a negative, one of the great affirmative teams of all time in college debate, the University of Houston in the form of Linda Listrom and Marvin Isger. Now, I've had the honor to introduce Ms. Listrom as the keynote speaker at the Tournament of Champions a couple years ago. And in that time, I said she's not just one of the great lawyers of our time, she is also one of the great humanitarians of our time, giving up a very, very successful law practice to go and become the executive director of the National Urban Debate League. Linda Listrom was a spectacular college debater. And her partner, Marvin Isger, is now a federal bankruptcy judge in Houston. He debated at the University of Houston, got an MBA at Stanford, absolutely brilliant, intimidating debater. And we arrived at the final round, my little freshman partner and I, circumnavigating a couple of rounds, winning some elim rounds, getting there by the finals. But there was a gap between the time that the semifinal round ended and the final round was to start. And Seton Hall had their library open. Well, Isger and Listrom, University of Houston, were running an affirmative team, an affirmative plan, and an affirmative case that hadn't lost a debate round in 6 straight tournaments. I mean, all the way through to elims in most of those tournaments. This was a great affirmative team. And their affirmative case was to simply put breathalyzers in automobiles, mandatory breathalyzers. And they claimed as an advantage that they would eliminate 50,000 automobile deaths from drunk driving a year. Okay. And you say, how does that mean you need to run a counterplan? Well, as I've told you, I haven't ever heard a counterplan in 7 years of high school debate. Haven't heard a counterplan in 3 years of college debate. Don't even know what the elements of a counterplan are because they were never discussed. But I'd remembered reading about it in a textbook by Professor Zarefsky and Patterson. Professor Zarefsky was at Northwestern University. Professor Patterson is the J.W. Patterson of the Tournament of Champions and was at the TOC and the J.W. Patterson Foundation. And after having looked at their book and said, gosh, there's this idea, I went to my coach and I said, Coach, I think we should run a counterplan. He looks at me and says, we've never run a counterplan. Nobody ever runs counterplan. And nobody had run counterplan. But I said, the only way we're going to beat this team, because we can't beat them straight up, their evidence is too good, their case is too good, their plan is 100% solvency. What can we do? So the counterplan debate began, and this is when debate first got weird for me. I went to the library, walked into the Seton Hall Library and found a book on prohibition. Went to my partner, told him in the first neg, this is what I need you to do. Let's not argue with the case. Let's not argue with disadvantages. Let's not present any arguments against the case. Let's run this counterplan and read these pages from this book about the benefits of reinstituting prohibition. So that was the first counterplan I ever ran. And Judge Isger, because I call him Judge now because that's what he is, stood up in his imposing, impressive fashion and said, it didn't work. So after the 2AC was done, I got a chance to cross-examine Judge Isger, and I asked him a very pointed question. Marvin, do you have a card for that? And he said, no. And I said, well, I have a book here from qualified authors that indicate that it did work to prevent 8,000 deaths from cirrhosis of the liver per year. So if you have our plan, you have no drunk driving arrests and no drunk driving accidents, and you have 8,000 saved lives from cirrhosis of the liver prevention. You have a card that says that's not going to happen. And his answer was no. And at the end of the day, because we had these policy-oriented judges that were more interested in how many lives were saved than anything else about a debate round issue and a debate round counterplan, well, guess what? That's what happened. We won the final round, qualified eventually for the national debate tournament, made it debating with a freshman to the elimination rounds of the national debate tournament, where we met our other team and they walked on. But it was a 4-1 decision because one of the judges thought we should have walked on. But in any event, the first counterplan debate I had was 7 years into debate in the second semester of my junior year in the final round of a major national college debate tournament against one of the best affirmative teams of all time. And I win the debate because the counterplan saved 8,000 more lives than the plan did. And from that moment on, the counterplan became something special. And eventually, the University of Redlands and Georgetown University began changing the concept of counterplans. And really, the first traditionally run counterplan that got great exposure was something called the studies counterplan. And in the mid to late 1970s, the studies counterplan became very important as a debate tool. And what would happen is teams would say, we like your plan, but we don't want to implement it now. We want to send it to this this commission of really bright scholars and have the counterplan evaluated. And then if it's great, we'll implement it. So from the studies counterplan came consult counterplans. And from consult counterplans came states counterplans. And the reality of counterplan growth occurred from the mid-70s on, and that issue of evidence became the answer to why counterplans could succeed, even if the counterplan was one to reinstitute prohibition. But they succeed because of superior evidence. Now, what are the elements of a counterplan? Well, they're real simple. The elements of a counterplan are always fourfold. Number one, you have a text, and that text should be written out, and that text should be available to be perused, because just like a plan text, the counterplan text stands in juxtaposition to the plan and says, is the counterplan somehow different than the plan? But in order to evaluate what the counterplan is, written in stone, it does need to be written. The second element of a counterplan is that it solves the case. Now, my first counterplan ever, reinstituting prohibition, seemingly solved the case because it had a book that said it denied alcohol to people. And of course, there were no drunk driving deaths because there wasn't that much driving. And as a result, I'm competitive with the plan action and the advantages because I could claim the same advantage as mandatory breathalyzers that would stop anyone from driving a car if they had alcohol in the breath. But the third element of the development of the counterplan as it became important in debate was that there would be a net benefit created from adoption of the counterplan that was not available through adoption of the plan. Now, for those of you who may be debating not on the national circuit, but instead in local circuits where you have parent judges or you have coaches that are judging that are not national coaches in terms of policy debate at the TOC level or college debaters, an argument should be when you're debating that your counterplan is not topical, because sometimes affirmative teams will say, hi, you're just adopting the topic. That's topical. And because we are the affirmative team bringing the topic to the debate round, you should vote for the affirmative, even if you like the counterplan, because you're voting for the topic. So you have to be very careful at the type of judge that you have to make certain that if this fourth element is present in the judge's mind, that fourth element should be present in your mind. So you have a text, you solve and you establish with evidence that you solve the case. You have a net benefit that the plan cannot capture. And if necessary, you establish that the counterplan is somehow non-topical. Well, what does the affirmative do? The affirmative responds to the counterplan typically in one of three ways, usually all three. They'll throw some theory at you by asking in cross-examination, well, how are you running your counterplan? And you say, it's our advocacy. It's conditional. They may say that the counterplan like I say, in front of parent judges is topical, so vote for us. It's a theory argument. Conditionality is a theory argument. Plan inclusiveness as a theory argument. How dare you include that aspect of our plan in your counterplan? You stole our idea, and theft of intellectual ideas is bad. So there are theory arguments that are run, and all that the affirmative team does is postulate that these are important and voting issues and they must be answered. And so all the negative team does in response is to answer them. Theory arguments are one way in which debaters on the affirmative win counterplan rounds. One of my best high school debaters that I coached a couple years ago that attended the University of Michigan, wound up getting to the semifinals of the national debate tournament in high school, got all the way to the elimination rounds of the Tournament of Champions in high school as a senior. On the affirmative, the only thing he won every affirmative round, his conditionality was bad. He knew the argument, he made the argument, he extended the argument, people knew he was going to go for the argument, and he kept winning the argument. So theory can't, and his name was Jacob Goldschlag. He's now a law student at the University of San Diego School of Law, but he was a semifinalist for the University of Michigan at the National Debate Tournament. Heck of a good affirmative debater, but a little bit limited in high school to conditionality. Theory is one place that affirmatives go. Negatives need to be prepared to put ink on paper to respond to affirmative theory arguments. The second form of attack on the counterplan from the affirmative is substance. And here the debate really devolves down to the substance of solvency. Does the counterplan actually solve the case or not? Does the counterplan solve the case better than the affirmative plan or not? Same thing is true in terms of substance on the net benefit. And you have to understand that sometimes superior solvency is the only net benefit of a counterplan. Because what the neg team will do is attack the solvency on case of the affirmative plan's ability to rectify or eliminate the problem that's isolated, and then claim that their counterplan has superior solvency, and that's the real net benefit. So the substantive arguments relating to a counterplan include, does it solve the case or not? Does it create the net benefit or not? And a subsidiary argument to that is, what are the external implications of the counterplan that the negative team may not have thought about? Are there independent disadvantages that arise from use of the counterplan that would not occur in the world of the plan? The final AF response that all negative teams need to be ready for is the PERM. The PERM says, okay, we can do the plan, and we can do the counterplan, and we gain the benefits of both. And if one is good, two are better. Do both. Don't just do the plan. Do the plan and the counterplan. And that way you capture the superior solvency, you capture the net benefit, and the permutation is usually a do both permutation. And this is where the doctrine comes in of independent justification for the counterplan that proves that the counterplan is mutually exclusive from the plan, that the net benefit to be created by the counterplan alone is better than the plan plus the counterplan. So as a consequence, you have to always understand when you're debating negative counterplan rounds that you need to be ready to answer the permutation. So when you're affirmative and hear a counterplan, always remember the PERM. It is the best offensive weapon against a counterplan. I will give you another illustration of why it's important. and it's the semifinal round of the national debate tournament in college a couple years ago. And one of my debaters is in the semifinal round of the national debate tournament, debating for the University of California at Berkeley. Probably the greatest, toughest kid I've ever met, by the name of Michael Wimsatt. He was one of my debaters in high school. He debated 4 years at UC Berkeley. And ask your college coaches who knew him or high school coaches who knew him, ask about Michael Wimsatt. He is literally the toughest kid I've ever met. But as he was sitting there listening to wonderful, marvelous, nationally successful debaters from Georgetown University stand up and respond after the 1AR and the 2NR, the words that he heard and why he couldn't ultimately get to the final round were, the 1AR dropped the perm. Now, even some of your lab instructors were judging that round, and I don't dislike them because it was a 5-0 on the counterplan. I still like those lab instructors that you've had and the directors of your institutes for having dropped another one of my debaters in the semifinal round of the national debate tournament. But the lesson is, even in the semifinals of the collegiate national debate tournament, the perm is magic for the negative. If you win the perm, you are far more likely to win the counterplan debate on the neg. Second, the AF has to debate solvency. The AF has to explain your solvency, answer their solvency, and think about harm areas that are not captured by the counterplan text. And finally, you need to understand framing and framework of the solvency debate, as well as the framing and framework of any disadvantages that might uniquely flow from the counterplan, or disadvantages that might uniquely flow from the plan that are not associated with the counterplan. In the counterplan debate, it's the little things that make a difference. In the semifinal round of that national debate tournament between Berkeley and Georgetown, it was a really big thing that made a difference. It was the dropping of the perm. Little things, however, are what differentiate counterplan success from counterplan failure. And those little things include comparing. You, as an argument maker, especially in the block and then the 2NR, must explain why your counterplan solves the problem in a bigger, better way. Maybe why your counterplan solves the problem faster, and that creates an independently unique net benefit. It's the little things and the debaters who can compare that make a difference. In addition, you should compare your evidence. Compare either the qualifications of your solvency advocates, compare the breadth of analysis and warrants of your solvency advocates, why you are bigger in terms of solving the problem, why you might be faster in terms of getting the problem ended before other harms occur, and why your evidence or your arguments or your warrants are better, make you a better counterplan debater. Second, you have to contrast. It's not enough to just compare, hi, we're better than they are. It's enough to contrast. Talk about differences in links. Talk about and discuss specific problems with evidence. And that's where you use cross-examination. And finally, to be effective in counterplan debating, you have to conclude. You need to package it all together and have an effective and compelling summary as to why the counterplan alone best solves the problem without creating other problems. Now, rather than just leaving this in the ether, let me tell you that I am an attorney and have been since 1980. So you can tell I'm old. And if the white hair didn't give it away, nothing will. But let me give you some little tips on the court's counterplan from an old lawyer, because negative teams, when I'm judging rounds, love to run a court's counterplan in front of me until they run it wrong. And then I explain it to them afterwards how their interpretation and analysis of the judicial process might be wrong. So this year, let me just focus on the court's counterplan and give you maybe a couple little tips just from an old lawyer. To begin with, let's understand the structure of the federal government, because the federal government is the actor in the plan. The legislative branch of government, Article 1, Section 8, has legislative power. Congress has the power to provide for the general welfare. That's the criminal justice system. Title 18 United States Code creates crimes. The criminal justice system is an adjunct of congressional legislation which creates a law which makes either the doing of something criminal or the not doing of something criminal. And punishment attaches to a law that Congress enacts. In addition to that, it is Congress that ultimately authorizes the rules of criminal procedure. And those rules of criminal procedure are what guide due process. We also have in the federal government the executive branch. Article 2 of the Constitution contains executive power. Executive power is vested in a president, and for purposes of the criminal justice topic, that includes the power to pardon, might affect sentencing cases, the power to appoint judges, the power to appoint or remove United States attorneys. Section 3 of Article 3 says that the president shall take care that the laws be faithfully executed. And finally, we have the judicial branch of government. Article 3 says that the judicial power shall be vested in one Supreme Court and such inferior courts as Congress may from time to time ordain and establish. Section 2 of Article 3 says that the judicial power extends to all cases arising under the laws of the United States. Now, it is in these last words that the laws be faithfully executed and the laws of the United States are what extend to the judicial power that Congress, the executive, and the judiciary, except in one instance, cannot help solve criminal justice problems in the states. So, here is the structure of Article 3 federal courts. The Supreme Court of the United States is the ultimate Article 3 court. It's the only one mentioned in Article 3. Congress has to create the inferior courts, and those inferior courts that Congress has created under Article 3 of the Constitution are the 13 United States Courts of Appeal, one of which is located in the District of Columbia, and 94 United States federal district courts, each of which are located in a geographic region. In California, where I practice law with the law firm Procopio, we have 4 federal district courts: the Northern District, Eastern District, Central District, and Southern District. You have to be, as an attorney, you have to get admitted in those districts. And if you are admitted to the state bar in those districts or to the Washington, D.C. bar, you then apply for admission to the district courts. Above those district courts in geographic areas are the courts of appeal. And above the courts of appeal is the United States Supreme Court. Now, the other thing that I wanted to mention about courts is that the structure of Article 1 United States courts is significant. Because under Article 1 of the Constitution, providing for the general welfare, Congress has created ancillary courts that are Article 1 courts that don't have, the judges do not have life tenure, they're not appointed by the president, and they don't have fixed salaries. Typically, they are either appointed by the circuit courts of appeal or they are appointed by the district court. And those areas are specialized areas of the law for bankruptcy judges and immigration law judges. But the question then becomes, what about magistrate judges? Well, magistrate judges are kind of like the first layer in the real world of the federal criminal justice system. Magistrate judges typically hear pleas. Magistrate judges typically hear guilty pleas. Magistrate judges typically hear arraignments. Magistrate judges typically hear pretrial motions governing discovery or other issues that may crop up. And those magistrate judges play a very important role in the criminal justice system, which means we now get to what's the federal system of justice. Because as I mentioned in the history of the Counterplan stuff and story, the history of the Counterplan story is it goes from reinstitute prohibition, which is just a flyer on a 3-hour gap between the semifinal round and the final round, to the studies counterplan, to the consult counterplans, and lastly, to the states counterplans, a different agent, a different arm of government. Now, why do the states counterplans have a problem in this current model of debate? And they really are important because there will be lots of them. But to understand how it impacts the system and how it impacts debate this year, you need to understand the structure of the federal system. It all begins with the Constitution of the United States. Now, the only mention of the states truly is in the 10th Amendment. It says all powers not delegated to the federal government and not forbidden to the states are reserved to the states. So the states are kind of like the end game of any other power that the federal government hasn't been given or that the states haven't been denied. The federal government, however, has powers that are limited and powers that are limited by definition in the Constitution. Now, what the Supreme Court has done is expanded those powers through interpretation of the General Welfare Clause, the Commerce Clause, the War Powers Clause, and those powers have expanded, but they haven't expanded to controlling crime inside every state. They have only expanded in the criminal field to the criminal code, which again is found in Title 18, United States Code. And those are the federal criminal laws. But I mentioned there's one exception, and it's out of that one exception that the Supreme Court counterplan is born. Now, how does it work into play? And to do that, you have to understand more about the structure of the federal government and the power relationships between states and the federal government. That power relationship is defined and creates, and the debate lingo for it is, the federalism disadvantage. And the powerful relationship between the United States Supreme Court speaking under the Constitution of the United States and states acting or not acting is that when the Supreme Court invalidates a federal or a state criminal justice practice and does so based upon the supreme law of the land, that decision by the United States Supreme Court applies in both federal and state criminal proceedings. So the benefit of the United States Supreme Court counterplan using the Constitution of the United States is that if the actor that is chosen is the Supreme Court of the United States acting pursuant to the US Constitution, that ruling by the United States Supreme Court would be binding on all federal and state criminal trial courts. Federal supremacy exists, and where the Constitution of the United States and Congress has, through its commerce power or other powers, taken complete control of a particular program or a particular area, and the federal government acts in its plenary capacity pursuant to Article 1, 2, or 3, the federal government's statutes and rules will control actions in that area. But the 10th Amendment leaves to state governments powers that are reserved. And those two powers are enormous as long as they are not forbidden to the states by the Constitution, or they are powers that are not expressly provided to the federal government as opposed to the states. So where does this all come in on this year's topic, and why is it that we have the counterplan debate at the United States Supreme Court level? Well, the Bill of Rights arises out of the 4th, 5th, 6th, 7th, and 8th Amendments to the United States Constitution. The Fourth Amendment governs search and seizure. The Fifth Amendment provides for due process, the right to a grand jury, forbids double jeopardy, meaning you can't be tried twice for the same offense, and it protects you against self-incrimination. The Sixth Amendment provides rights to a speedy trial, provides the rights to counsel, an impartial jury. You're entitled to identify and know the name of your accusers and the nature of the charges against you. That's an arraignment. The Seventh Amendment gives you a right to an impartial jury, and the Eighth Amendment prohibits cruel and unusual punishment. But those Bill of Rights, originally when the Constitution and the amendments were enacted, applied only to the federal government. It took the Civil War and the 14th Amendment 3 years after the Civil War to have a constitutional amendment in the 14th Amendment, which said due process rights are now to be imposed and required of the states as well as the federal government. So it was only after the Civil War, 3 years afterwards, that all of these Bill of Rights apply to state governments pursuant to the federal Constitution. Now, each state, I swear, has their own constitution. And each state, I'm telling you, has, even though I'm not allowed to practice law without a license in any state other than California, but each state has a constitution that contains their own Bill of Rights. So there are state constitutions and the US federal Constitution. But when the Supreme Court makes a ruling on any of these amendments as applied to a practice or a procedure, be it state or federal, pursuant to one of these amendments through the 14th Amendment, then the Supreme Court's action gains you solvency for preventing criminal justice system problems through the federal government. But it's not necessarily enacting, and that's talk to people about topicality and what enacting means. So for the topic, the Bill of Rights typically might be forensic science changes or improvements would be covered by the Fourth, the Fifth, the Sixth, and the Eighth Amendments. Policing powers, regulating search and seizure, regulating rights to counsel, regulating jury instructions, regulating the right to a fair trial, regulating the right to be not killed or how you're not killed if you receive the death penalty in state or federal trial. And finally, sentencing issues obviously relate to the Sixth Amendment, the Seventh Amendment, and the Eighth Amendment. So the topic covers the Bill of Rights in every particular. That means that the Supreme Court's use in debates can be effective. Now, what you need to know this year is that, and read topicality on what enact means, because it may mean that a plan which uses the Supreme Court might not be topical because the Supreme Court doesn't enact anything. The Supreme Court reviews and adjudicates things, but the court's branch can be used as part of the plan because it is certainly part of the federal government. It is probably more likely that it will be used this year, Supreme Court, as a counterplan, but very importantly, understand that there are possibilities for a state's court's counterplan that might be out there, but you might have some problems with uniformity because the state Supreme Courts are kind of all over the map on things. But that would be an issue relating to one of the two big advantages that get involved with counterplan debates. So debating the courts this year will involve plans, and the big issue there might be topicality enact. The agent counterplan, if the plan says we use the Supreme Court, that might be a T issue, but if the plan says we use the executive branch through executive order, the courts might be a better way to go. If the plan says we use Congress of the United States to enact something, and the counterplan says we use the Supreme Court, that might be an agent counterplan of distinction. And the big thing with the counterplan debate this year and the courts is certainly leading up to the election, the politics disadvantage. Arguments are made that the courts are more immune from public scrutiny, and hence the politics disadvantage may not apply if the court does the criminal justice reform, as opposed to Congress or the president doing it. And the politics disadvantage is the big advantage that will be used for the net benefit in a court's counterplan debate. The other thing is federalism, and you want to be very, very wary of the federalism disadvantage, because there are great arguments that eliminating federalism creates some big problems, and so there's a net benefit to the federalism disad that might apply in a counterplan, court's counterplan debate. But the biggest issue for me as a lawyer is that somebody's going to be arguing very effectively that the Supreme Court counterplan has superior solvency because, unlike a congressional plan or an executive order plan, when the Supreme Court acts pursuant to the 14th Amendment and due process, it can invalidate systemic injustice, it can invalidate systemic inequality because it applies the 14th Amendment to both state and federal prosecution. So this year, getting cognizant of the court's counterplan is good because it's an election year, and up till the election, it's going to be an option for every negative team. And for the Supreme Court, it applies both to federal criminal actions, and when acting pursuant to the US Constitution, it also applies to state criminal actions. And the way it happens is through the process of what's called judicial review. The original case, Marbury versus Madison, the Supreme Court gave themselves the power to decide whether or not acts of Congress or the executive were unconstitutional. And so what happens is that an act, either by Congress in creating a bad law, or an act by an agent of the federal government's executive branch in performing something under the criminal justice system, has to be reviewed. And the review is one of two formulas. It is either reviewed as an act under the basis of strict scrutiny, or it is reviewed as a power of government under the rational basis test. Strict scrutiny requires that there be a protected class being denied equal protection of the laws, or strict scrutiny requires that a guaranteed right under the Constitution to human beings is being denied by the action of the government, state or fed. A rational basis just says that if you're not involved with a protected class and you're not involved with a guaranteed due process right, if the government has a lawful purpose in enacting the law and a rational basis, then the courts cannot interfere and change that idea. So litigated issues that lead to problems and how the Supreme Court works its way in, basically for the criminal justice system, involves application of due process protections directly through the 3rd, 4th, 5th, 6th, 7th, and 8th, 4th, 5th, 6th, 7th, and 8th amendments to federal actions, through the 14th Amendment of the Constitution to state procedural and substantive actions. Due process violations can either be procedural, meaning there's a violation of equal protection, or there's some process right that an individual is entitled to that they didn't get, or they can be substantive violations, meaning this whole group of government agents does not give people their Miranda rights. Due process violations require reversal of conviction. Same thing is true, or the exclusion of evidence. Same thing is true with equal protection of the laws, and that's going to be a huge issue, particularly this year. That the law may be enacted fairly, but applied unequally as a violation of the due process clause of the 5th Amendment and of the due process clause of equal protection of the laws under the 14th Amendment. All right, so where does it fit in? Why is Supreme Court counterplan better than reinstitute prohibition? Well, the Supreme Court counterplan this year is most effectively applied in the solvency debate. So I want to tell you one thing, that if you're having me as a judge at the end of the round, don't run a Supreme Court counterplan that says in the next available test case, something's going to happen, because there ain't no such thing in federal courts as a test case. Article 3 of the Constitution limits federal court jurisdiction to cases and controversies, meaning there are no hypothetical cases. There are no cases that offer hypotheses for the court to say, well, if this were to happen, that would be the result. Courts don't issue hypothetical opinions. Courts only decide actual controversies. And second, the power on courts. Now, there may be other counterplans that are out there. Well, the District of Columbia Circuit will issue the following ruling, or the en banc panel of the Ninth Circuit will issue the following ruling. Federal courts have limited jurisdiction, and while there is a tremendous debate now about whether or not a federal district court can issue a nationwide injunction against an executive practice, while that debate is percolating up through the federal court system, understand that the reality of life is that district courts and the circuit courts of appeal have geographic limits. The only federal court without a geographic limit is the United States Supreme Court. The mechanics of the court's counterplan, the Constitution of the United States, should be used as the baseline. Use of lower courts as the agent of action, probably not a very effective or solvency idea or solvent idea unless you have really great evidence from someplace. Use of state courts is a possibility, but again, you have geographic limitations, and fiating something on 50 different state Supreme Courts and courts in Guam or the Supreme Court of Puerto Rico, all of those things may be troublesome in terms of solvency, and understanding that there's a distinction between reversal of an existing decision and overturning of a prior court decision, and how you use language in developing your counterplan matters. So I wouldn't be much of a teacher if I didn't give you what you should do as opposed to what you shouldn't do. Here's some language that might help you in terms of developing or crafting your counterplan. It's on the screen. The United States Supreme Court should reverse blank, a particular decision on the grounds that blank constitutes a violation of the blank amendment to the United States Constitution. That would be at a decision out of either a state Supreme Court or reversing a decision out of one of the circuit courts of appeal, or issuing a writ of certiorari, which is the second language, to reverse a decision. And that might constitute an overruling of a prior Supreme Court decision. And so that implicates the question of what's called why the Supreme Court can change its mind. And the answer is because it can. And the reality of life is that precedent and the doctrine of what's called stare decisis can change with the composition of the justices on the United States Supreme Court. You're going to go through that a lot because that literature will be essential to the politics debate, and particularly the elections debate this year, on whether or not the Supreme Court is actually perceived. But the makeup and composition of the United States Supreme Court often plays a role in guiding what's going on. So you'll note from the language on the screen that we're talking about reversing a particular case, and we are giving a reason based upon the 14th Amendment applied to the 5th Amendment, or the 14th Amendment as applied to the 6th Amendment, or the 7th or the 8th Amendment. And that's how a counterplan text might look. I'm almost done, but I promised you that what I would do is teach you how debate saved the world. And so what I want to do for a second is talk to you about how debate actually did save the world. And debate saved the world in terms of what's going on with the government. Debate saved the world because the single most vulnerable time in the history of the world was the Cuban Missile Crisis. And empirically, I mean, from actual firsthand testimony, I can tell you that a high school debater from Nebraska who became a critical advisor to the President of the United States when the most dangerous time in history was approaching, as Russian ships carrying nuclear weapons was coming to Cuba and was about to cross a red line in the ocean, that high school debater said directly that relying on one of the tools that he had used in high school debate, he crafted at President Kennedy's instructions a letter to Nikita Khrushchev, which incorporated some of Khrushchev's ideas. So he's enacting a pick counter plan. And he changed a little bit of what was the device that was going to be used, or the agent to be used. So it's a agent pick counter plan. They took Khrushchev's letter, modified it with their counter plan, and sent it back to Cuba, sent it back to Khrushchev, and mysteriously, the Russian ships carrying nuclear missiles to Cuba turned around. A pick counter plan based on the experience of a high school debater in Nebraska who became a critical foreign policy advisor to the President of the United States, prevented Armageddon, in his own words, at the time of the most crucial problems that the world had ever faced, in the possibility of a nuclear exchange between the Soviet Union, now a lot of Russia, and the United States of America over Cuba. If you don't believe me, the specific thing is there, the URL, I guess is what it's called. You can tell I am old. The URL is there. And if you want to Google it, the words that you want to Google are Russert, Tim Russert, Sorensen, the presidential advisor and former Nebraska high school debater, and Doris Kearns Goodwin, the presidential historian and scholar. And Google it with Meet the Press and the date of the performance on Meet, where it's published, and read it for yourself. Pick counterplan with agent change, sent back to Khrushchev, save the world. May 19th, 2008, probably the greatest card in the history of debate. If you get it, find it, and cut it right. So I'm done, and I wanted to say thank you very much for listening. Thank you for listening to my story of how 7 years in debate. Never heard a counterplan until I decided to run one against one of the great affirmatives of all time and one of the great college debate teams of all time. Wanted to tell you that debate does make a difference, and your attention to this program hopefully will help you as you debate the counterplan for this topic, the court's counterplan. But I would always encourage you to debate well. I would secondarily encourage you to be honest, and be honest in everything that you do, your disclosure, be honest in answering questions and cross-acts. Don't try and hide stuff, because the best argument is a true argument. And if you have true arguments, you will have great success in this activity and in life. But always remember, your job as a high school student, and even those of you who are lab leaders in college, your job as a college student to get grades, because grades matter more than debate matters in your overall ability to eventually change the world, and perhaps use a counterplan someday to save the world. So thank you all very much, and my best wishes to all of you, and my congratulations for you having chosen a tremendous institute with wonderful lab leaders and very successful debaters. as you will spend your summer becoming better able to have success in this activity that I've been involved in since 1967. Thank you all.